Yes, ma'am. I would like to get on the record that I would like to fire my lawyer on
You don't, you don't have a lawyer. Remember, we've already been through this. You represent yourself.
Right, but the one that's on standby, I would like him replaced with another lawyer.
Proceeding with the arraignment is your true and correct name, Sylvester Larnell Evans.
Sylvester Larnell Evans Jr.
And what is your date of birth? Earlier we went over your rights to arraignment. Any questions about your rights to arraignment that I wasn't able to answer?
No, I don't have any questions, but I would like to speak with the judge if possible.
You'll get it in a moment.
What is the city's recommendation regarding release?
The city is requesting bail or bond amount of $500 on each of the 6 cases. Defendant has a significant warrant fight appear history, including 1 active warrant out of Tacoma Municipal Court. City believes the defendant is a high risk of future failures to appear. And also the city is requesting the court find sufficient evidence to set bail or bond on the 2 review matters as well. City believes the defendant is a high risk of not complying with court orders and a risk of disruption administration of justice.
Any objection, Mr. Ioannati?
Yes, ma'am. I would like to speak. I would like to.
Just a minute. I'm going to talk to your attorney for a second. And then if you want to say something and it's okay with your attorney, I'll hear it then.
Mr. Evans indicated that he did want to say stuff, and I told him he couldn't. He also asked me to represent information to the court. He is asking the court to release him on his personal recognizance. He wants to assure the court that he would show up in person. He said he was not aware of any of his missed court dates. But I think he also wants to address the court, and I told him not to discuss the facts of the case, and he said he understood that.
All right, Mr. Evans, what do you want to say?
Yes, ma'am. And I do acknowledge the fact that the previous failure to appear, but if you give me a chance at a personal bond this time, I want to deliver a letter to you.
Buckle up, guys. Today we're going to witness the arraignment where Mr. Evans shocks the courtroom by insisting on firing his standby counsel. He argues irreconcilable differences, and the judge patiently explains that he already represents himself. This tense opening sets the stage, exposing his combative style and laying the groundwork for the battles over bail and self-representation that will drive what follows. Notice how his defiance foreshadows the clash to come.
Hand to hand, I will make the court date because I want to deliver a letter with a message to you, hand to hand, which also will be attention to Chief Justice Roberts of the Supreme Court. So I want to assure you that if you give me a chance this time, I assure you I will show up at court, because not only is this connected to the state charges, it's also connected to a federal things that I have going on that I don't want to discuss. But I assure you I will show up. And if you can also, I'm in a tank. I would like to represent myself, and I'm in a tank to where I'm getting mistreated. I'm on 23-hour lockdown. I'm on crutches. I have a leg injury, and it's extremely difficult and mentally strenuous, the things that they're doing to me inside of the jail. That's why I say I want to, if you give me a chance at a personal bond, I assure you I will appear with the letter in my hand for your insight, as well as attention to Chief Justice Roberts so he can be alerted to what's going on.
You have 17 warrants out of our court alone.
You have my word on that. You have my word, Your Honor, that I will appear. I want to...
sir, with all due respect, you just don't come back. You have 17 prior warrants out of our court. It is your duty to keep your address updated. I think $500 each case is very reasonable. I
can't afford that at the moment. That's why I was asking for personal recognizance. If you give me a chance, I assure you I will be there, because I want to prove that I'm innocent of these charges, and I was at the airport on your orders on personal travel.
I have never ordered anyone to go to the airport.
No, the last set of paperwork you gave me, it said that I can appear, I can go to the airport for personal travel, and that's the only time I've been there. The only time, I assure you.
I'm imposing bail in the amount of $500 each case.
And also they have me in a tank to where if I'm representing myself, it's going to be extremely difficult. I don't have any access to the kiosk because it's broke. They have me on 23-hour lockdown. I didn't do anything. I haven't been violent or anything with anyone. They just, for some reason, I'm in a segregation tank. I don't know if it's because of my injury or what, but also it's affected my leg because I'm rehabbing my leg, and it's messing with the muscles and nerves because I need to keep my leg active and in motion, and they have me in 23-hour lockdown. I'm not even in general population. So I'm asking humbly and respectfully, could you please grant me one more chance at a PR bond, please?
The prosecutor demands $500 bail on each of 6 counts, citing Mr. Evans's failure to appear history. Evans passionately argues for a personal recognizance bond, offering to hand-deliver a sealed letter to Chief Justice Roberts. The judge weighs his promise, but imposes cash bail and appoints standby counsel. The dialogue crackles with tension as the judge questions Evans's commitment given his history.
And Mr. Evans, you have an active warrant right now out of Tacoma Municipal Court.
I'll resolve that as well, because when I went to court, they initially told me it was dismissed. So I guess they just put something back out. I'll resolve that as well. But if I humbly and respectfully ask that you please give me one chance to prove myself, please, because it's almost unbearable for me to represent myself and with my leg injury and the conditions they have me in, and me getting mistreated in the jail as well.
Okay, I've made up my mind. I'm imposing bail in the amount of $500 each case. And I will appoint Mr. Ionati while you're in custody, so that you will have a way. And if you're wanting to do your own research, perhaps you and he can work out a way.
Ma'am, that's the whole point I was trying to make. Mr. Ionetti is not properly represent me. That's why I want to represent myself. That's how I got back in this situation to where I was reviewed, because before I wanted to do a fast and speedy trial, he never filed the motions. That's why I want to represent myself, and I asked for a PR bond so I can hand you a letter informing you of everything that's going on, as well as a letter that you can forward to Chief Justice Roberts to alert him what's going on. And
I'm not forwarding anything to Chief Justice Roberts.
I understand, but I have evidence that will exonerate me. And I wanted to hand that letter to you in person.
Anything you give to the court, you have to give to the city as well. I can't look at it unless the city has it as well.
I understand, but I wanted to file it and make sure that you're in position soon as I hand it to you or the courts, that they're able to go ahead on and put a seal on it so it's not exposing, because anything I send from any letters I mail out.
You have to make a whole motion to file it under seal. Sir, there's a lot. This is very complicated what you're proposing.
I understand, and I have the evidence that proves that will prove and will exonerate me, but I don't want to send everything through this jail because there's so many eyes that's going to see it. In addition to that, the circumstances and the conditions they have me in is unfeasible. There's no access to the kiosk where I can look at the law library. In addition to that, I'm in a
Mr. Ionati, when would you like to set this over till?
Thursday.
All right, Mr. Evans, we'll see you back here on Thursday.
Would I be able to request a PR bond at that time, or is everything?
No, you're only entitled to one bail hearing unless there's been a change in circumstances.
Evans lays out his harsh jail conditions, 23-hour lockdown, broken law kiosk, and a serious leg injury that hobbles him on crutches. He again begs for a PR bond, stressing mental strain and his need to rehab. Standby counsel and the judge probe his ability to research and represent himself in these circumstances. They emphasize that self-representation requires adequate resources and that physical hardship alone does not guarantee bond.
What about the jail conditions they have me in? I'm in 23-hour lockdown. I didn't do anything, and I'm not even don't even have access to the law library because the kiosk is busted.
I've appointed Mr. Ionati while you're in custody, and or at the very least a standby counsel. You can talk to him about how you want to deal with that.
Okay, and is it okay if I represent myself?
You'll have to go through there's a form to fill out.
Can Mr. Ionetti give me that form, and can this be on record that I'm saying that I want to represent myself and that I need the forms or whatever I need to be, and I would like a fast and speedy trial as well.
Yes. you'll have
Well,
all-
you've said that the speedy trial in custody is 60 days.
I understand that, but I want it on record because last time I told Mr. Ionetti this, he never made any motions to get the process started. That's why
There is no motion to make to get it started. The clock starts ticking at arraignment.
I understand, but I would like to represent myself if
And that's fine. You can represent yourself. I mean, you can file the petition to represent yourself. I don't know whether I'll
it's
accept
gonna
it.
it's gonna be extremely difficult to do that with the circumstances I'm in.
I can give you the information and go over what you need with you. Spoke with him because he's in custody right now. I know he wants to address his in custody status with the court, but I figured this needs to be addressed first. We discussed if he's in custody, he needs access to certain things and that unlikely he can get. So he would want an attorney on standby to assist him with that. And I said that I don't have any conflicts, so I don't have any issues doing that if that's the case. But just so the court's aware. But I know he wants to address his conditions of release, but he also wanted to represent himself.
I would like to speak to Your Honor before we disconnect if possible, please.
All right, Mr. Evans, so it's my understanding that you do not want an attorney to assist you. Is that correct?
Like you said, if he could be on standby, I would like to represent myself because I invoked my right as a Aboriginal Native American Indian chief. That's I asked if you got that letter. So I have certain constitutional rights that's afforded to me. In addition to that, I have a leg injury where I'm on crutches and they have me in 23-hour lockdown. I didn't do anything wrong. And I was trying to see if it's possible, based on the fact that I invoked my right as an Aboriginal Native American Indian chief, that I definitely will appear at every appearance if I could get a pre-recognizance bond due to the circumstances. I assure you I'll show up, especially that I invoke my right as a Native American Indian chief.
Evans formally invokes his right to self-representation and demands the paperwork. The judge outlines the formality and warns that the speedy trial clock starts at arraignment. Evans insists the previous counsel's inaction stalled his rights. The exchange underscores the procedural hurdles of pro se defense and how missed filings can derail a defendant's quest for a swift trial. It illustrates how navigating court rules without counsel can compound delays and jeopardize case strategy.
And as the prosecutor stated earlier, Mr. Williams, I guess, what is the change? It doesn't sound as if you're noting any change of circumstance from when the court saw you on Monday and set bail.
I sent the proof in the letter that I mailed
No,
out.
it wasn't provided to the city. I haven't seen any proof. And I would say that's not a change in circumstances.
I mailed the letter out on Tuesday with the evidence and the proof invoking my rights as a Native American Indian chief. So I'll be working to get this case removed to the federal courts. I need to also file in the federal courts a notice to remove as well. And it's going to be extremely difficult for me to do that from here in prison. So that's why I was asking if I could get a PR bond. I assure you I'll show up. I'm not going to play with my rights like that as a Native American Indian chief. In addition to that, I'm in 23-hour lockdown with my crutches and it's affecting my leg. I broke my tibia and fibula in 5-6 different places. And the muscles and the nerves in my leg are getting worse because I'm not able to rehab it like I'm supposed to.
Ms. Chenmuller, seeing that I wasn't here on Monday, what is the bail currently set at?
500 cash or bond on each of the 6 cases.
And does Mr. Does Mr. Williams have, what is his FTA history?
He does have a substantial warrant fight history, including an active warrant out of Tacoma Municipal Court. Also, has not complied with court orders, and that he repeatedly returns to the airport we have 4 pre-trials and 2 reviews involving those allegations, the same
And
allegation
in
before the
addition to
court
that,
today. Has warrant failure to appear history in pretty much every case.
What is his date of birth? I'm trying to find him on Jack's.
my last name is Evans, it's not Williams.
It is 6/7/84.
And also, there's no evidence that I was trespassing each time I was there on valid personal travel. So this case lacks evidence, which is also why I asked to have it dismissed in the letter as well.
He went into that on Monday as well.
The focus shifts to a pretrial conference where Evans reiterates his custody struggles and the need for legal assistance. Standby counsel confirms no conflicts and offers to stand by. The court notes Evans's intent to address release conditions later. This segment emphasizes the importance of aligning legal support with a defendant's in custody status and highlights the court's procedural pacing. It shows how courts juggle logistical concerns amid tight calendars and safety protocols.
And also, I never invoked my right as a Native American Indian chief. This time I did. So therefore, I will not miss not one court date, I assure you. Can you please?
I'm not sure what you being a Native American chief has anything to do with you coming to court.
Because I represent a sovereign state, and as a sovereign state, I have the right to have these cases heard before the United States of America. I've put the details that prove what I'm saying, and also it should prompt everything to be moved to the United States Supreme Court, especially with some of the details that I put in there regarding my circumstances and what I have going on, which I'm sure Chief Justice Roberts can verify once the process or whatever, which I'm trying to go through the process now, but it's going to be very difficult to do this from inside the jail. But as a chief of a sovereign tribe that's federally and internationally recognized, I have the right constitutionally to go to, I have immunity, and I have the right as a sovereign state to have this cases heard before the United States of America. In addition to that, I have different types of immunity that I fall under as well.
All right, Mr. Evans, so I gave you an opportunity to speak just to make sure I understood exactly what was happening in this case since I was not the judge on Monday. I have had an opportunity to review your criminal history, and I do see that you have had warrants in pretty much every case that has been filed against you that I can see in the state of Washington. So right now, I'm not hearing any change of circumstance that would give me any change in circumstance that would allow me to change the bail from $500 on each case. So that will remain as previously set on Monday.
And also, would you be able to look at a oral motion to dismiss due to lack of evidence at this hearing?
You would have to do that, Mr. Evans. You are acting on your behalf as an attorney. So that is a motion that would need to come from you and or your attorney.
I actually mailed in a letter. I was trying to see if the courts received that letter because that was in the letter that I mailed.
Okay, we do not have that letter at this time. So we're going to set this matter for another pretrial hearing.
Could you set it for sometime next week when you guys get the letter so you can understand everything I'm saying?
I believe we will have to set it in due course in regards to the court's availability.
Yes, Your Honor.
Evans asserts his status as an Aboriginal Native American Indian chief, claiming sovereign immunity to justify PR bond. The judge reviews his criminal record and finds no new basis to alter bail. This exchange reveals how fringe legal theories collide with established procedure, underscoring the court's insistence that recognized jurisdictional grounds, not sovereign claims, govern bail decisions. It highlights the gap between unconventional self-styled rights and the judiciary's reliance on statutory authority and precedent.
May I inquire if a copy of that was sent to the city?
I mailed it off to the clerk's office, and also, Your Honor, could you please put on note that, I requested that that letter get sealed due to the protection of innocent life, not only mine, but others that's at stake due to the information I revealed about me being a Native American Indian chief and the evidence that I've revealed in it. That, could you please put on note that I asked that it be sealed immediately?
The motion's being heard if we don't receive copies.
Did you hear that, Mr. Evans?
They're gonna, no, ma'am, could you repeat it, please?
The city has stated, since you are acting as your own attorney, that if they do not receive the information that you've provided to the court, that they will be objecting. It is a responsibility of you or your attorney to provide any information to the court and to the prosecutor.
All I can do is mail the letter off. I mailed it off. I don't know if the guards kept it or if it gets lost in the mail. I don't know. I can remail the letter, or I can rewrite it and remail it off. But I mailed the letter off. I definitely sent it off, and I have the guard that picked it up. I have documented the guard that picked the letter up. So I definitely mailed it off, and it should be on camera that I handed the letter to the guard.
All right.
The city's entitled to an opportunity to respond. We would need it at the very latest by Monday. I mean, if we're setting it for Wednesday.
I mailed the letter off Tuesday. So it may get there today or tomorrow. Because it shouldn't take no more than 1 or 2 days for it to get right there to CTAC court. I mailed it to the 4800 188th Street, and I put on there to the clerk. I attentioned it to the clerk, so that letter shouldn't take that long. If it doesn't come to you guys, that means it got lost in the mail or something like that, and I would have to rewrite it. I do have a rough draft of it. So I will be able to read it out to you verbatim Wednesday if you like, if you haven't received the letter by Wednesday. I did keep a rough draft of the letter, so I could read it out to you verbatim. Or if you don't mind, if you could give me a second, I can go and get the rough draft out of my cell right now and read it to you.
No, we are not ready to address that today. So we will address these matters again on Wednesday, May 29th.
Evans probes whether his sealed for safety letter arrived and demands notice. The judge reminds him his letter must be served on the prosecutor to avoid ex parte contact. A new pretrial is scheduled once the city receives the submission. This section underscores service requirements in criminal cases and how procedural missteps can stall a defendant's attempt to present evidence. It demonstrates the balance courts maintain between fair notice and preventing unauthorized communication.
Yes, ma'am. I would like to get on the record that I would like to fire my lawyer on stand.
You don't have a lawyer. Remember, we've already been through this. You represent yourself.
Right, but the one that's on standby, I would like him replaced with another lawyer.
I'm not going to do that. What's the basis for that?
Because irreconcilable differences. The fact that you had to explain to me what an affirmative defense is, when he explained it to me, it was polar opposites. It's nothing that it's irreconcilable differences. It's like, I would rather work with someone else.
So if you do that, sir, speedy trial starts over today. Disqualification of counsel is a triggering event for new commencement.
Okay, so I can't replace him without restarting my speedy trial dates.
Correct.
Which will prolong my time in jail.
I don't know that.
Possibly.
Possibly.
All right, so due to that, it's gonna possibly prolong the time I have in jail. I'll do my best to work with this guy.
Mr. Evans, do you want me to represent to the court what we had discussed? I mean, you didn't mention what you just mentioned, but the subpoenas and what you're asking for?
I'm gonna write a letter to her, mail it. I have it mailed out today. I'm gonna write a letter to her as well as the Supreme Court of Washington, the state of Washington, with the things that we discussed, but you can let her know the people that I want subpoenaed.
Sir, so any letter that you send to the court, you must include the city. You have to include the prosecutor or I can't look at it.
Yes, ma'am.
Okay.
What you mean by I must include the prosecutor?
You have to send it to them as well.
I'm gonna send it to the clerk of court, so they should.
Nope, it's your burden to serve the city.
What's the address for the city?
It's the same building.
It's the same building, so I have to send two different letters?
Yes,
I mean, I have to make a copy of it and
Correct.
send. I have no way of making a copy from inside the jail.
you'll have to make one longhand then.
Oh, well, I don't even have the paper I have is only enough to send one letter. They in the jail, they're not even giving me sufficient things to even properly do what you're asking me.
Evan struggles to obtain paper to copy his letter for the city. Standby counsel offers to serve once filed. The judge warns that failing to serve the prosecutor is ex parte communication. This segment spotlights the practical hurdles pro-SE defendants face. Simple logistics like copies and mail delivery can derail their efforts to comply with court directives. It reminds viewers that procedural compliance often hinges on basic administrative steps that many defendants underestimate.
Perhaps you could send it to Mr. Ionati and then he can serve the city and the court.
I would ask that Mr. Ionati, once it's filed, the letter that I'm going to mail out, once it's filed, he make a copy and send it to the prosecutor.
I cannot look at it unless the city is included.
I understand, but what I said is that once it's filed, that Mr. Ionati gets a copy and send it to the prosecutor, and then you can look at it, which still should be before my next court date.
So that's it. This is the problem with representing yourself, sir, is that you do not understand the rules of criminal procedure. And you can't, you're having ex parte contact if you send something only to the court and not the city.
I'm not in, well, can you tell the jail, give me sufficient paper so I can make 2 copies? Because they're not giving me the what I need to do what you're asking me.
And that's why I'm suggesting that you send it to Mr. Ionati and then he can make copies for both the court and the city.
Okay, Mr. Ionati, is there a way for you to come? Is there an address that I send this to? I don't have any information on you, Mr. Ionati.
I believe it's on the paper. The orders that you got should have had our address, but we'll get you our address today. And Your Honor, I guess what I spoke with Mr. Evans, and he asked me to let the court know that he intends on subpoenaing Clarence Thomas, and then the United States District Court for the Eastern District of Louisiana, the Honorable Judge Nanette Brown. He's also asking that we subpoena the Apostle Derry G. McCoy Sr. Witnesses for this case or these cases that need to be brought in. I did, and I told him that I was able to, and he said I could. I just want to make sure, Mr. Evans, I can address the case number that you said.
I don't want to, like I said,
2412.
that's a matter of secret state privilege. I don't want you discussing that.
Okay.
So Mr. Evans, in order to subpoena people in another state, you need to actually go to the Superior Court of those states. Neither Mr. Ionati nor I have subpoena power that goes beyond the borders of the state of Washington.
Would that be grounds to have this case removed to federal courts?
I don't believe so. This is not an issue of federal law. It's not a civil case with amount in controversy over $75,000.
Evans demands subpoenas for Clarence Thomas and a self-styled Apostle Darrell G. McCoy Sr. The judge patiently explains that neither counsel holds authority to subpoena witnesses out of state, and that additional jurisdictional steps through local superior courts would be required. This exchange underscores the limits of a defendant's power and the formalities governing witness subpoenas. It highlights how grandiose demands collide with procedural reality and how defendants must navigate jurisdictional boundaries when seeking testimony.
Nor is it involving parties in other sides of the states, in separate states. There's no diversity jurisdiction. There's no subject matter jurisdiction.
It's definitely, the restitution is going to exceed $75,000 in the case that I'm found innocent by the jury. In addition to that, it would be biased by the city based on the witnesses will be able to provide testimony that will possibly exonerate me.
Is the city seeking any restitution?
I definitely stated that in the letter, and I asked I made that clearly known to Mr. Ionetti if he's doing any.
Sir, you can't get restitution. I mean, I don't know what the basis is for restitution.
If I'm found innocent, I would like restitution for my businesses for each day I sat in jail and they lost potential money.
There is a rule that provides for that is not restitution in the sense that it would go to federal court. This is not a federal, there's nothing in here.
The amount that I'm asking for.
That has nothing to do with it. That's a separate issue. Is the city aware of any issue that would cause this case to be removed to federal court?
Evans attempts to remove his airport trespass charge to federal court, citing dual jurisdiction and tribal immunity. The judge methodically debunks each claim, emphasizing statutory jurisdiction, lack of diversity, and absence of evidence for his tribal chief status. Bail remains unchanged, and the case stays in state court. This closing segment reinforces how legal theories must align with established law. And if you enjoyed this breakdown, remember to like the video and subscribe to the channel, and we'll see you in the next video.